Hi, I'm Lois Beasley Carlo with some bankruptcy advice. This is on once I'm in a 7 or 13, can I convert it? Am I stuck in it? Now, you can convert and or modify your Chapter 13 cases when you're in one. For example, you're in a 13 paying everything and doing just fine. Your husband or your wife dies. You need to go see your attorney and tell them, look, I can't pay all these bills anymore. Sometimes you just have to dismiss your bankruptcy and start over. Sometimes you can convert a bankruptcy to another type of bankruptcy, like a 13. You could convert to a 7 if you're eligible. The only way the attorney's going to know is by giving him all the legal documents so that they can make that decision. Sometimes you and your wife or husband are going to get divorced, and if y'all do get divorced, then one or the other one might say, I'm not going to pay these bills anymore. I'm going to go Chapter 7. Yeah, we can bifurcate a bankruptcy case. We can sever them. We can dismiss one and one person and take the debts out and object to all the claims that's the other person's. We can dismiss the case and file two separate new cases. What needs to be done in your particular case is going to be a matter between you and the attorney. And you just have to take them all of your financial documents so they can make that best decision for you. Always ask your attorney for a copy of your paperwork. They can email them to you. We can pull discharges for years and years. Sometimes, we've had to go to Atlanta to get papers out of storage or whatever, but you can usually always get a copy of those papers. There may be a small fee years down the road to get them from the bankruptcy court if the attorney no longer has them. So it'd be a good idea to get a copy of the bankruptcy petition and the discharge papers and keep them all in a safe place. Fires happen, people lose documents, so there are means to get those documents later on. Do I have to go to court every time a court hearing is set? The only one that can tell you that is your attorney. Plan to go unless you talk to your attorney. There are a lot of meetings that the attorney can handle for you, and there's a lot of times you don't even have to go to court. Sometimes things can be settled with creditors. You do need to go meet with your attorney about a week before each court date so you can look at all the paperwork that's been filed and see if there's something that you need to do. Now, what's it going to cost me to go bankruptcy? Well, you're going to have to pay the bankruptcy court filing fee. Right now, the bankruptcy court filing fee is like $335 or $310 depending on whether you're filing a 7 or a 13. Now, a 13, if you qualify, you can pay $77.50 a month for 4 months. What would disqualify you is if you'd had a prior Chapter 13 dismissed and you hadn't paid the court filing fee. Then the court is going to make you pay the filing fee up front the next time. When you file a bankruptcy, it's a good idea to get a copy of your credit report. The attorney can usually pull those for you. You can bring a copy of your credit report in, but if you're going to have to pay for it, just if the attorney's got the process to do it, just let the attorney pull it for you. Now, don't go calling your creditors until you talk to the attorney and let the attorney guide you in what to say to your creditors, because you don't need to misrepresent facts to them. Sometimes you can work out payment agreements with them, sometimes you can't. Sometimes the attorney might be able to negotiate some debt with you if you're not in such a bad shape that you can't do that. Sometimes not. Sometimes we negotiate debt for people instead of them filing 13. Now, at the end of your bankruptcy, again, you're not going to get a discharge if you don't go sign papers to get out of bankruptcy. And it's not going to take long, but it's kind of like common sense. You had to sign a bunch of paperwork to get into bankruptcy. You got to sign some paperwork to get out of bankruptcy. Now, you're going to have to prove who you are to the attorney and to the court by bringing your driver's license. Some courts make you bring your Social Security card. Pretty much all the bankruptcy courts are going to make you produce your tax return and your spouse's tax return. If you've done something fraudulent on your tax returns, the attorney may say you've got to go fix your tax returns before they can file bankruptcy for you. For example, if both the husband and wife are claiming head of household, we make them go fix the tax returns before we file a bankruptcy for them, because that's just a big red flag of fraud. You both can't claim head of household if you're living together. You have to disclose all forms of income to your attorney: Social Security, child support, rental income, annuities, retirement. Whatever your form of income is, you have to disclose it. You have to get copies of that income to the attorney, because the court is going to require copies of that information. Sometimes if you're paid cash, you can do an affidavit that you paid cash. You're going to have to keep insurance on your house and your car if you're keeping it in a 13. And you're probably going to have to get that proof to your attorney. I tell people to immediately go ahead and get that insurance proof faxed over to the creditor when you're about to file bankruptcy, because they're going to ask for it anyway, and you may as well get your insurance company to do it ahead of time. Now, most creditors aren't supposed to contact you while you're in a 13, but the IRS in the state of Alabama are going to keep sending you letters. And the letters will just tell you what you'll owe if your bankruptcy gets dismissed. A bankruptcy can stop the IRS in the state of Alabama from garnishing you. They can stop student loans from garnishing you. You may be able to bankrupt on part or all of your debt to the IRS when you're in a bankruptcy, depending on how old the debt is. And we'll get to that at a later point in time. Sometimes you can keep your post-petition tax refund, sometimes you can't. Sometimes your attorney will have to give creditors a copy of your tax returns. They'll usually ask you before doing that. Sometimes, there'll be a random audit of your bankruptcy court case, and you might have to produce bank statements and tax returns for a period of years. Jurisdictions and issues. Make sure you tell your attorney all the places you've lived in the last 2 or 3 years. Now, sometimes you might decide to do a loan modification on your mortgage. Your attorney can best advise you about a loan modification, and if your creditor does offer you one, that may have to be court approved. If you get in a motor vehicle accident while you're in bankruptcy, that settlement is going to have to be court approved. The court will handle dispersing the money or write an order how the money is to be dispersed. If somebody dies after a bankruptcy's been filed and they've been to court, the family can keep paying the case for them if they want to. If somebody dies before they've even been to court, a lot of times the bankruptcy is just going to get dismissed, unless an estate's filed and somebody takes over pretty quickly. Now, you can only file a Chapter 7 bankruptcy every 8 years. A Chapter 13, you can stay in a 13 your whole life, basically, but you only get a discharge if the 13's been filed 4 years after the last one was filed. The 8 years on the filing starts from date of filing to date of filing for a Chapter 7. Now, one of the things that might qualify you or disqualify you from filing a Chapter 7 is the asset that you own. If you have too many paid-for vehicles, too much equity in your house, you may not be able to go Chapter 7. You might have to go into a 13. The exemptions change year to year. Right now in Alabama, the exemption is $15,000 for your real property, $7,500 for your personal property. How do you determine the equity in your home? You take the payoff on your mortgage, use a tax card to show the tax value, and subtract it. If you have a lot of repairs that need done, get those estimates for repair to the attorney, and that might knock down some of the value of your home. Might have to get a recent appraisal. Might have to get estimates from all those people for the repairs, actual estimates. Maybe need to bring pictures. We've given pictures and estimates for repair to bankruptcy trustees. Every year you may be required to take your tax returns to the attorneys. Depends on the type of case and how the case has been set up. Logic dictates you can't bring guns or knives or anything like that into a bankruptcy court. Any federal courthouse you're not going to be able to bring a weapon into. Now, in a 13, how do I know how much to pay? The attorney will set you up a payment. Part of your payment may be for the filing fees. Your payments may be higher at first. Part of your payments may be for adequate protection to creditors. What's an adequate protection payment? Adequate protection payment is 1% of the value of the car, for example, or the furniture, any secured debt that you have. Can you add in rent? Depends on when the lease renews. You can add in rent, of course, if you're leaving the place, but if your lease renews next month and you're filing bankruptcy this month, all of the rent has to be paid by next month.